All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. We welcome all of you to the Kansas Supreme Court. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 10:30 docket.
Your Honor, may I- The first case on the 10:30 a.m. docket for Tuesday, December 10th, 2024 is appeal number 125761. State of Kansas versus Casino Royale, Donier, Cazaron, Collins, Sedgwick County, briefs both sides.
May it please the court, Casino Royale Collins appears through counsel Casper Shire, Kansas Appellate Defender. Chief Justice, could I please have 3 minutes for rebuttal today?
3 minutes granted.
Thank you, Your Honor.
May it please the court, Assistant District Attorney Chelsea Anderson on behalf of the state of Kansas, ready and present for argument. Present and ready for argument.
Second case is appeal number 126130. State of Kansas versus Christopher Sean Adams, Ellis County, briefs both sides.
May it please the court, the state appears by Chris Ailslager, Deputy Solicitor General, present and ready for argument. And Ms. Chief Justice, the state would request 3 minutes of rebuttal time.
3 minutes is granted. Thank you.
May it please the court, Heather Fletcher on behalf of Appellee Christopher Adams, and I'm present and ready for argument.
Your Honor, that concludes our 10:30 docket.
All right. Thank you, Mr. Shima. This time I will call 125761, State of Kansas versus Collins.
May it please the court, Casino Royale Collins appears through counsel Casper Shire, Kansas Appellate Defender. The district court did not advise Casino Royale Collins of his appeal rights when revoking his probation and sending him to prison for 13 years. Nobody came to the jail to talk to Casino Royale about his appeal rights until over half of the 14 days that he had to file a notice of appeal had already run. And even then, he did not get complete notice of his appeal rights. Despite all of this, Casino Royale Collins managed to secure a notice of appeal within 8 days of that jail meeting.
We don't know that from the record, though, that he didn't get complete notice. I mean, we don't really know whether his attorney advised him that he had a right to counsel, even if he were indigent. It's just, there's an absence of reference to that, isn't there?
I have two responses to that, Your Honor. If the court finds that the evidence is lacking, it was the state's burden to put on evidence of showing that Casino Royale got notice of his appeal rights from some other source. So if it is lacking, that's the state's problem, not Casino Royale's. Second, I want to focus on precisely what defense counsel said. He said that Casino Royale, and I'm quoting, still was afforded the right to appeal, and that there are appellate attorneys that are more versed in appellate law, and that if he wanted to file the appeal, I would file appeal. It would then be out of my hands, and he can talk to an appellate attorney about it.
But that's not advising him that he has a right to an attorney at no cost if he's indigent.
That's exactly the problem, Your
Right.
Honor.
Okay, so can we infer it? I
No,
mean, we have some case law where we can infer that the district court made findings that aren't directly referenced.
we cannot do that here, Your Honor, because this would be inadequate if this was the district court's rights advisory. That's not enough. The district court has to advise somebody who has the right to appeal that specifically they have the right to appointed counsel. Court didn't do that. This would not have been enough if the court had said this, and since it would not have been enough if the court says it, it can't be enough to cure the court's failure.
Now, the state says, well, he's had other cases. He knows that.
Not as an adult, Your Honor. This was his first experience. Casino Royale was 18 years old at the time of his revocation hearing. This was a juvenile case that got waived up. This was his first experience with the adult criminal legal system. Any experience that he had with the juvenile legal system really isn't the same. This was the first time that he'd had his probation revoked in an adult case, and he would have had absolutely no reason to know what his appeal rights were.
Help me understand what if we presume your argument to be correct, help me understand the remedy here. What's the remedy that you're asking for? And let's flesh that out a little bit.
We're asking this court to reinstate the appeal.
Okay, but under that shifting burden of proof, it was the state's burden to show that there was actual knowledge. We don't have that here, but it seems like there's still one more step, a district court making a finding that the defendant would have actually pursued that appeal. And I'm wondering, I understand there's some evidence that suggests that, yes, in fact, he would have, but without the finding, does that box us in a little bit?
Not on these facts, Your Honor. The timing here is important. And Ortiz, at the end of the day, is about fairness. And the fair thing to do here, if he's where we know at the very least that he's not advised that he has 14 days to appeal his case until 9 days into the clock, the fair thing to do is start that clock when he's actually advised of his appeal rights. And he did secure a notice of appeal just 8 days after that. So this is a case where actions speak louder than words. When he was advised of his appeal rights, he made timely efforts to get the notice of appeal filed. When I reviewed this court's case law about what we're looking for when we're talking about whether an appeal would have been pursued, the appellant is not allowed to let the matter drop. Casino Royale absolutely did not let the matter drop here. When he was not advised of his appeal rights, he called his attorney to ask that attorney to come down and explain things to him. That didn't happen for over a week. And I understand sometimes there are reasons for that, but that is not Casino Royale's fault. It is not his fault that he lost more than half his time before he even knew that he had 2 weeks to appeal. And even after that, he was never told that he had the right to appellate counsel. And the difference between being told that there are appellate attorneys out there who are pretty good at this, you might want to talk to one, and being told that you will be appointed an attorney if you choose to appeal this case who's going to help you is a very important difference.
So you're not really suggesting that, I mean, to follow up on Justice Wall's question, which kind of infers, do we need to send this back for a specific finding? You're really asking us to kind of create a new rule here that we haven't done before that I'm aware of starting the clock partway through the time at the time of the point of advisement.
Well, Ortiz is a judicially created rule, Your Honor, so I don't see any reason why this court couldn't do that. And I think it would be the fair outcome here. Regardless, whether this court goes that route or not, we do see Casino Royale taking prompt action once he's informed of his appeal rights. And that's inconsistent with the finding that he wouldn't have appealed had he been timely advised.
So we can reach a conclusion as a matter of law based on the circumstances that he would have pursued the appeal. Is that the argument now? I mean, is that what you're saying? I'm trying to just connect the dots.
Sure.
How we get
No,
there.
and the first two prongs of the Patton analysis, and Patton, of course, is the case that lays out the burden shifting test, are certainly legal conclusions. Did the court advise? Well, we've got a transcript. We reached the legal conclusion that either the court did or didn't. did the state meet the burden of showing he got the advice from somewhere else? Well, we've got the record, he either did or he didn't. The third patent factor, I think, needs to be treated the same way. If the first two are legal conclusions, then the third one should be too. And here the facts support the legal conclusion that, you know, when he's advised of at least part of his rights and he appeals within 8 days, yes, as a matter of law, he satisfies that factor.
Doesn't Patton go against that though? Because Patton, let me set it up a little bit. Patton addressed many, many different factual variations of what can happen, what the defendant's knowledge might be. And then it boiled it down to this simple three-phase nut, if you will. As to the first exception, Patton requires that a district court provide a defendant with three pieces of information. One, a right to appeal the severity level of the sentence. Two, any appeal must be taken within at that time 10 days. And three, if the defendant is indigent, an attorney will be appointed for the purpose of taking any desired appeal. Okay, that didn't happen. So then Patton said, if the defendant shows the district court failed, then the burden shifts to the state to prove that the defendant had actual knowledge of those three things. And then if the state fails to carry its burden, which you assert that third thing that he's entitled to counsel if he's indigent never happened, was never proved, then you go to step three. If the state fails to carry its burden, the burden then shifts back to the defendant to show that they would have appealed had they been correctly advised. So there are essentially three phases. If the district court fails, then the state has to prove those three things somehow. If the state fails, then it shifts to the defendant to say, if I'd known that, I would have appealed, right? Isn't that what's required under Patton?
I think, Your Honor, that you've got the analysis right. I would push back on the idea that if Cassian Royal doesn't stand up in court and say, if I would have been advised timely, I would have appealed within 14 days.
Well, isn't the problem here that phase 2 and phase 3 never happened? Which, couldn't that be resolved on remand?
That it could be resolved on remand. I just don't think that the court needs to remand it. I think based on the facts that we have here, this court can conclude that the only order, the only finding that would be supported by substantial competent evidence is that if timely advised, Cassian Royal would have timely appealed.
How can we infer that?
I just don't see any other conclusion to draw from the fact that after he's advised of at least some of his rights, he gets his notice of appeal on file within 8 days.
Let me ask you a question about that. So the district court made a credibility finding about his attorney's testimony that okay, so the court emphasized his testimony regarding this meeting, and Collins didn't really remember the meeting, in particular at the jail. The court therefore credited his testimony, where Collins said, I don't want to file a notice of appeal. What do we do with that factual finding from below? Because, I mean, the case law says if somebody says, I don't want to file an appeal, and then you're saying, well, but we can infer from the fact that he later did it, that he did want to file an appeal, but that seems like a change of mind.
Sure.
You know, based on the factual findings from the district court. And I don't know what we do with the factual findings of the district court.
Well, Your Honor, and I think it runs together with the problem of Cassian Royal was working with a very condensed timeline because he didn't get notice of his rights at the time of his probation revocation hearing. So presumably the reason the legislature allows 14 days and doesn't require you to say, yes, I'm appealing, or no, I'm not, right there from council table when the sentence is imposed, is that we want to allow people at least a little bit of time to think about this. And that can include changing your mind, right?
Right, but if if the district court found that he said, I don't want to appeal.
Right. And the testimony further was that, on the 8th day, Casino Royale, after the jail meeting, Casino Royale got in touch with counsel and said, you know what, I do. And defense counsel therefore immediately filed the notice of appeal. So you're right. Well, I don't know, but the facts the district court found show that Casino Royale reached one decision on the day of the jail meeting and then changed his mind and reached a different one 8 days later.
Right, and so.
I'm sorry, go ahead,
No,
Your Honor.
I was just gonna say, so let's say we have a case with a little bit different facts and the defendant changes her mind 5 hours before the 14 days expires.
Sure.
So in that situation, are we to start the clock anew? Even though for the 13 and a half days, she said she didn't want to appeal?
No, I don't think so, Your Honor. I think what starts the clock is knowing that you've got 14 days, right? And the earliest that happened in this case is the day of the jail meeting. So yes, it took Casino Royale 8 days from the time he was told you've got 14 days to appeal to actually get that appeal on file. But the 9 days of delay that preceded that jail meeting were not Casino Royale's fault. They were
I'm sorry, I didn't mean to interrupt. I thought you were done.
No, I was just going to say they were due to the neglect of the district court in not putting Casino Royale on notice of his rights right away. And again, I'm not throwing stones here because I understand people are busy, but ideally the jail meeting would have happened much sooner than 9 days into the clock. It didn't, and none of that is Casino Royale's fault.
But if Mr. Casino Royale has not yet been advised that he's entitled to an attorney, if he's indigent, it's free to him. If he still hasn't been advised of that, and we don't accept the state's argument that, oh, he's had other cases, he knew that, then he still hasn't been advised of the 3 things he is supposed to know. So does that mean under your argument, the 14 days hasn't even started yet?
I think that's essentially what this court now is describing, I think, is what happened in Scoville. And Scoville dealt with the court failing to advise the appellant of I think at that time it was 10 days, doesn't matter. But failing to advise the appellant of the time limit. And that was part of the McAdams situation. He didn't take an appeal for over a year.
So your
And
client's appeal is timely. It's not even late. Ortiz doesn't even apply, right?
In
Well, it's
Scoville,
not
Your Honor?
late. No, I'm sorry. In this situation, he hasn't been advised yet. So
Right.
his
And
appeal isn't even late.
I think that's right under the Scoville logic, Your Honor. Basically what this court said in Scoville was, well, he was never fully advised of his rights. Therefore, he gets to take an out of time notice of appeal. And arguably we're skipping a patent step there. But I think the way to read that is, when you're never advised of your rights, your clock never stops. Your clock never starts. And I see that I'm over my time here, so I appreciate this court's attention. I will conclude by asking this court to reverse the Court of Appeals in the District Court and to reinstate this appeal.
May it please the court, Assistant District Attorney Chelsea Anderson on behalf of the state of Kansas. As we know, this matter stems from the defendant's attempt to appeal his probation revocation, which was filed 3 days out of time. As the questions have addressed the first exception to the Ortiz matter, I will start there and note that the defendant claims that this argument that he was not fully informed was always before the court, and that the Court of Appeals therefore was wrong in finding that it was an unpreserved matter, despite appellant arguing specifically for the exceptions to consider unpreserved arguments in his opening brief, clearly anticipating that the Court of Appeals would find that it was a new argument. His petition for review then asserts, as I stated, that he's always made this claim, and he cites to the closing argument from the Ortiz hearing in support of that. However, this appears to be factually incorrect and ignores the manner in which the argument was made at the hearing. The state can only address the matters that are challenged, the issues that are brought before the court, and the defendant simply failed to explore that information. Despite the defendant's complaint that he was faulted for the incomplete record, the Court of Appeals was correct in placing that burden on the defendant, as it is a well-established rule that the appellant has the burden to designate a record sufficient to establish the claimed error. And without an adequate record, the appellant's claim of alleged error fails.
Well,
This-
wasn't it the state's burden to prove that those three elements did actually exist with the district court's failure to do so?
Well, the state would have been required to, if it had been properly on notice that that was being argued. I would know.
Didn't the Court of Appeals just get it wrong and put the burden of proof on the defendant instead of the state?
No, I would say that they did not get it wrong. That was another argument, that the burden was improperly shifted to the defendant. But as you noted, and I think Justice, I believe, Wall noted, that there is another step, that Patton said that if the transcript shows that the defendant was not adequately informed by the district court and the state does not demonstrate actual knowledge, then the defendant must prove that a timely appeal would have been filed. And as the court has already noted, credibility findings were made, and this court does not reassess those findings. And the district court, in making those findings, determined that that factually the defendant would not have timely appealed. Now, again, I note that I would argue that the state was not actually on notice that all three advisories that are required post-sentencing were at issue here. This was, again, from a probation revocation, and the response to the show cause order indicated only the third exception of Ortiz. Then the counsel who is appointed for the Ortiz matter filed a motion to reinstate appeal, which really wasn't necessary, but was filed. And at that point, it was expanded to include the first exception, but he only argued that the court had failed to advise the defendant of his right to appeal.
Do you disagree, just for my clarity, you don't disagree that what I'll call the first step, that the transcripts show that there was not an adequate advisory from the court?
I do not disagree that the court did not advise the defendant at the conclusion of the revocation hearing.
Okay, so your preservation argument goes to what the state would have had to show about actual knowledge?
I'm sorry,
I-
I just want to make sure I understand exactly what you're asking.
Yes, we're trying to understand each other. I appreciate that. It sounded to me like your preservation argument was, look, we acknowledge we have the burden to show actual knowledge, but the defendant didn't put all three prongs of actual knowledge into issue.
Correct.
And does a defendant have to do that once they've made the transcript showing?
Well, the state would argue yes, because again, the
Why,
state,
why would they, just conceptually, why would that be the case? When our case law is very clear about what the state has to show. I mean, doesn't our case law put it in issue essentially?
I suppose the court could interpret it that way. The state believes that it was a conscious decision on the part of defense counsel to hone in specifically on the court's failure as well as just the 14-day timeline. And that was what the state was responding to. As you can see from the closing argument made, as the Court of Appeals noted, the defendant did not challenge whether the state met its burden, nor argue that the state had failed to establish that the defendant had actual knowledge at the district court level Ortiz hearing. Therefore, the Court of Appeals, like I said, was correct in finding that this was a new argument unpreserved for appeal, because it would have required the Court of Appeals to engage in fact-finding or assume facts not in the record, which, as I mentioned earlier, it is the defendant's burden to establish that record.
But the district court ruling landed, it didn't go past the first step, did it? I mean, didn't the district court ruling find that there was, I'm sorry, second, maybe it's step. Was the ruling that there was an adequate advisement or that there was actual knowledge, or was it an alternative ruling by the district court? Can you help me remember the record there?
As I recall, the district court did indicate that it felt the state had shown that the discussion that probation counsel had with defendant did cure the but ultimately, I think the main finding was that the district court believed the defendant would not have timely appealed had he been so informed or had there not been any deficiency in his representation.
Does that finding take into account an adequate advisement that would include the right to appointment of counsel? Does that, do you understand what my question, what I'm asking there?
I just want to make sure, are you saying does the finding that the court's lack of advisory was cured? Or are you saying the final?
The final finding that he did not want to pursue an appeal, I guess, does it matter that, does that finding presume that a actual knowledge of the full extent of the right to counsel, that the defendant was aware of that full right, and even if he had actual knowledge of the full right, would have not pursued an appeal? I guess my problem, if the district court makes a finding that he didn't want to pursue an appeal, but there's not actual knowledge of the full extent of the right, how do we square that factual finding with this sort of legal deficiency, if that makes sense?
Well, as I stated, this court has said in Patton that, I mean, based on the Patton analysis, I don't think it does matter whether the court is able to find that the state met its burden, because ultimately the burden shifts back to the defendant to prove that he would have timely appealed had he been properly informed. And I think one of the things that I noted while opposing counsel was arguing his side, there was a lot of talk about this time period that went by before he got over to the jail, which ignores the fact that the probation revocation attorney also testified that immediately after the hearing was over, he advised him of his right to appeal and said, let me know if you want to discuss it further. Now, again, it wasn't explored what that entailed. It wasn't explored whether he just said, hey, you have a right to appeal, call me if you want to, or if he said all three things. I mean, you could easily say all three things in less than 90 seconds, which was the testimony. So again, it wasn't explored, and I believe based on what this court has previously said, it is absolutely the defendant's burden, as even in Patton, with regard to that first exception, this court said that the evidentiary burden rests on the defendant. So, and specifically said, even if the state can't demonstrate that actual knowledge, the defendant must establish he would have appealed.
Isn't the best evidence for what someone would have done if something was different, what the defendant actually did? I mean, that's opposing counsel's argument is, look, we don't have to speculate. We know what he actually did. What he actually did was file the appeal within 8 days.
Well, what we know is that he was told he had a right to appeal. He immediately calls the probation revocation counsel and wants to, address it further. So this argument that, well, only 8 days passed is inaccurate. He knew immediately after the hearing that he had some right to appeal. Now, it's arguable whether he was told of the timeline. I don't know, because it wasn't developed down below. But the bottom line is he was told he had the right to appeal. He said, yeah, let's talk. And the attorney goes to the jail with the full expectation that he's going to be filing an appeal for this guy. And then the guy says, no, never mind, I don't want to, after being fully advised. So,
But
yes, but
concerning appellate counsel, though, doesn't the record reflect that Mr. Royal's attorney told him, if you want to file an appeal, I'll file it and then we'll talk to an appellate lawyer who knows a lot more about those things than I do. I'm not going to assume that if somebody tells me I can go to the doctor to talk about something that they'll know more about, I'm not going to assume the doctor's going to see me for free and that everything is going to be taken care of at no cost to me. Don't you think that his conclusion might be a little different if he knew that he could appeal for free?
I don't know. Again, it wasn't established. It wasn't developed. There were no follow-up questions whatsoever.
We have an odd situation here where it actually, what Justice Wilson says rings very true. It actually benefits the defendant a great deal if it were true that at the jailhouse meeting, the defendant was actually fully informed of his rights, because that gives a clear reason to change one's mind. Oh, I can do it for free, right? So why shouldn't the defendant get the benefit of that?
Again, there's no basis for this court in the record to determine that he didn't know that. It wasn't.
But that suggests the state should lose, don't you think? Because if a defendant takes 8 days between the time the defendant finds out that he can appeal with state appointed counsel, finds that out, and 8 days later it gets filed, I mean, that's pretty strong evidence that he, quote, would have filed the appeal had he been fully informed.
But that's unfortunately not what you have before you. You don't have those facts. You have a probation revocation counsel saying, I told him immediately after, you've got a right to appeal. We don't know exactly what that conversation was because it wasn't developed. And then we've got this conversation at the jail with his appointed attorney, who had an appointed attorney throughout the entire pendency of the.
It does put the state in the odd position of arguing that the defendant should lose because there's no evidence he was ever fully informed of his rights,
Well, this court
right?
would be well within its right to remand for more
Okay.
fact finding, but unless this court is going to go against precedent, this court doesn't make additional engage in fact find. So I understand that we're in a little bit of a predicament, but I do think that ultimately Patton indicates that the burden is on the defendant. And I see I'm out of time, so unless there are further questions, I will ask this court to affirm the courts below. Thank you.
May I ask one more question?
Yes.
Do you agree that the state did not prove during the Ortiz hearing the defendant had been advised that he could appeal for free if he was indigent?
I believe that wasn't developed, so it wasn't in the record. Thank you.
Thank you.
Unless this court has questions, I think I'll briefly close my argument the same way defense counsel closed his at the Ortiz hearing, which is Caston Royal did everything that we would want him to do in this situation. And he shouldn't be penalized for that. He shouldn't be in a better position by going back to the jail and twiddling his thumbs for 17 days and then filing a notice of appeal after not being advised in court. He took action. He didn't let the matter rest, and he shouldn't be in a worse position for doing that.
So can I explore your argument has some resonance just in terms of fairness and based on the timeline, but it does raise perhaps a wrinkle in Patton that this court has never really addressed, which is this whole idea that the state, even if the advisory is not given by the court, the state can still prevail if they demonstrate actual knowledge. I don't think Patton or any of our cases say what is supposed to happen if the state succeeds in demonstrating actual knowledge. In other words, does the 14-day clock start over? That's kind of your argument as I take it.
Yes.
Can you address that? Like, for example, what if we had a hypothetical where the court does not advise and the evidence is overwhelming and even uncontroverted that the hypothetical defendant received actual knowledge 13 and a half days. You know, Justice Standridge is only 5 hours before the deadline expires.
Right.
What is supposed to happen? Do we have any case law, or what's your argument about? I think I know your argument, but.
No, I don't think there is any case law on it. And I assume that's one of the reasons why we're here today, Your Honor, to be quite honest. But, you know, as I think I said it earlier, at the end of the day, Ortiz is a court-made exception in the interest of fundamental fairness. So I think it is absolutely within this court's power to clarify what we should do and to set a fair rule. And I think the fairest, easiest to apply rule is to start the clock when notice.
And your argument, if I could summarize it and see if you agree with it, is that we should essentially clarify Patton's third step, or the third step of proving that you would have filed the appeal by saying you would have filed the appeal within 14 days of receiving the proper advisory, as opposed to the defendant who's 13 and a half days in having to file the appeal within 6 hours or 12 hours.
Yes, I think that would be fair and logical. It doesn't make any sense that an appellant who gets notice 13 and a half days in is functionally without remedy, and somebody who gets notice 14 and a half days in is in great shape.
Right.
That's neither fair nor logical.
Any other questions? Thank you, counsel.
Thank you, Your Honor.
Thank you to both of you for your arguments this morning. The court will take this matter under. Now calls 126130, State of Kansas versus Christopher Sean Adams.
May it please the court, Chris Elsleger, Deputy Solicitor General, appearing on behalf of the state. And again, I'd like to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
This case brings us to the intersection of the court's truth-seeking function and an individual's Fifth Amendment right against self-incrimination. And generally speaking, when these two come into conflict, the Fifth Amendment right wins. However, the law has mechanisms to eliminate that conflict. And one of those mechanisms is immunity. And both this court and the United States Supreme Court have held that a grant of use and derivative use immunity is coextensive with the Fifth Amendment right against self-incrimination. That means someone that has been granted immunity cannot refuse to testify on the basis of the Fifth Amendment right. And that's what happened in this case. The witness, Lang, was granted use and derivative use immunity. However, the district court and the Court of Appeals majority here chose to boldly go where no court has ever gone before, and held that not only does the Fifth Amendment right, or the Fifth Amendment, give you the right to refuse to testify on the grounds that it might incriminate you, but it also gives you the right to refuse to testify because you don't want to tell the truth.
Just so
Like-
I want to make sure I'm not oversimplifying the case, but the immunity that the state offered boils down to, if you come into this proceeding and tell the truth, we won't use that testimony in your perjury case, which was pending at the time. Is that all we're talking about, or is there something else?
Well, it was use and derivative use immunity, meaning we couldn't use that, whatever she said, for anything other than what again, both statutory law and case law have said that, the Fifth Amendment doesn't grant a witness a license to lie. So you can never grant immunity for perjury, meaning future perjury. Now, they couldn't use any statement she made to prove the prior perjury. And that, the county attorney made that clear. That was, they had no intention of doing that. He granted her use and derivative use immunity for anything she could have said on the stand that might incriminate her. And again,
Right, but I guess I was maybe oversimplifying it a bit, but the real threat was this pending perjury case.
Correct.
And so we just want to make sure, even though you can't use it for anything else, but real sure that anything she says in the trial of the other defendant doesn't get put into the perjury case to show, aha, see, you perjured yourself before.
Right. And that was made abundantly clear by the grant of immunity.
What wasn't the threat actually the promise of the prosecutor or statement by the prosecutor that if you testify at Adams' trial like you did in prelim, you will get an additional perjury charge?
I don't know if the prosecutor ever said that. That was her fear. I don't believe the prosecutor ever threatened that he would do that. Although obviously that's that is a logical conclusion, but
okay. And then I think the majority on the Court of Appeals took issue because there's this sort of built-in assumption that that testimony was false. But what's happened with the underlying perjury case, the only filed perjury case, in the time that's unfolded since the Court of Appeals opinion and where we are today?
It went to trial. She was found guilty of perjury and she filed a notice of appeal. I don't know if the appeal has been docketed.
And does, that seems to at least strike at sort of the heart of the majority's analysis of the Court of Appeals that sort of took issue with this assumption that that the dissent at least was presuming that preliminary hearing testimony was false. what can we do with that conviction? Is that, I mean, does that lend enough credibility to truth or falsity? Or does it even matter whether the testimony was true or false?
Well, I've always taken the position that it really doesn't matter. It did seem to be important to the majority. And as I point out in the brief, though, the majority kind of ignored the fact that the judge at the preliminary hearing made a credibility determination, said he didn't think she was truthful. It's also disturbing because it kind of shows a certain breathtaking amount of cynicism about the ethics of prosecutors to suggest that a prosecutor would charge perjury just to try to manipulate the future testimony. The prosecutor is ethically bound to only file charges which he thinks he can prove beyond a reasonable doubt, and has probable cause, and so on. But then beyond that, as the dissent made below, and as we made in our brief, every witness that comes into a trial has the danger, the risk of being charged with perjury if they get on the stand and lie. And every witnesses don't come in a vacuum, right? Lawyers don't just call witnesses out of the blue. Every witness has prior statements, either whether they've made them to police or to investigators, to other witnesses, statements they made at the scene, maybe on camera. There's always prior evidence that if the witness takes the stand and testifies contrary to that prior evidence, they all run the risk of a perjury charge, even if they've been granted immunity. And the case law has made that abundantly clear. Only the majority below has made this ruling. I could find no other court in the country that has agreed with the majority opinion here. And the majority even went so far as to suggest that, kind of what you said, that the threat, even if she hadn't been charged, that just threatening her with a charge of perjury would be enough to give a Fifth Amendment right. And other courts around the country have seen that very fact pattern and said, no, that's wrong. As the U.S. Supreme Court said in Applebaum, there's no right to anticipatory perjury. Okay, so she really wasn't in any different position than any other witness. And the problem, I mean, the rationale of the majority below is really, I mean, it's really disturbing because in my view, it both validates and encourages perjury. I mean, if the prosecutor ignores the perjury at the preliminary hearing that he's seen himself and that the judge has identified as probably false, then he essentially validates that if he does nothing, and he encourages the witness to just go to trial and perjure herself again and commit the same perjury at the actual trial. So that can't be right. But if the prosecutor charges perjury, according to the Court of Appeals below, then he creates a new Fifth Amendment right for the witness that did not exist before, and that would not have existed. Just kind of out of whole cloth, out of thin air, is now created, that gives the witness the right to refuse to testify at trial. And I was thinking about all the different permutations this could take, and I thought, well, this is one thing that hit me. I mean, organized crime would love this. I mean, could you imagine if the Godfather gets charged with a crime? And the witnesses against him are all his henchmen, and so they come into the preliminary hearing and they just blatantly lie. They lie and exonerate him. And if the prosecutor charges them with perjury, well, come trial for the Godfather, they just say, well, Fifth Amendment, and then there's no evidence. Godfather walks away. Or since they got away with perjury before, if the prosecutor doesn't charge the perjury, he essentially validates it. They come to trial and they can, again, give the exact same testimony, exonerate the Godfather. Yeah, they might get charged. They take one for the team later on, but the Godfather walks. This rule makes no sense. The Court of Appeals decision is simply, it's illogical, and it goes against all the case law involving the Fifth Amendment and where it intersects with perjury. The dissent, Chief Judge Arnold Berger got it right. She went to great lengths, relying on the Applebaum case, which I think is the appropriate precedent to rely on. And if there aren't any further questions on that, I would simply urge you all to agree with Chief Judge Arnold Berger and reverse the Court of Appeals majority in the district court below. Thank you.
May it please the court, Heather Fletcher appearing on behalf of appellee Christopher Adams. clearly the appellee does not agree with opposing counsel. It is our position that the Court of Appeals actually did get this right. The circumstances in this case, as I think everybody's aware, are pretty unique. I could not find a case either that was directly on point with the circumstances that we are dealing with here today. Ms. Lang was a state's witness who the state had endorsed, subpoenaed her, and to come to the preliminary hearing of Mr. Adams. She did that. She testified, and at that point, the state then decided that what she had testified to was perjury, and then made the decision to charge Ms. Lang with perjury related to that testimony that she offered at the preliminary hearing. They also filed an affidavit setting out what they believed was perjury that committed by Ms. Lang. They then subpoenaed her to testify at the trial of Mr. Adams, where the same set of facts were at issue. The state had that discretion whether to charge Ms. Lang or not charge her. They had the discretion to decide what to charge her with and when to charge her with it. They chose to charge her when they did, and that was their decision. They then created this situation where they wanted to bring her back, put her under oath, and if she testified consistently with how she testified at the preliminary hearing, they were intending to charge her again with a second.
Opposing counsel said there's nothing really in the record, just this is a factual issue, to show that they actually verbalized that or conveyed. If you testify the same way as in the preliminary hearing, then you'll be subject to a second charge. Is that just what she was thinking and her lawyer was thinking, or is there something in the record to show that they threatened her?
No, actually, I believe it is in the record that the state noted during preliminary hearing, as he was developing this perjury concept during the preliminary hearing, he made it clear that if she testified that way again, if I recall correctly from the record, I don't remember the exact quote, something about the effect that he would charge her with perjury.
Which he did.
Yes,
But
he absolutely did. And then in chambers, he reiterated that the day of the jury trial.
and that is in the record?
I believe it is, yes.
A conference in chambers?
I believe it.
And
it
what
was-
did he say? What did the state say? Sorry.
I would have
that-
to look here in my brief. I believe I included it in my brief.
Was she in chambers?
Yes, Your Honor.
She was in chambers right before trial.
Yes. The scenario was the jury was in the courtroom. We were in chambers for preliminary matters. The court reporter was brought in. The state was there. I was there. The defendant was there. Miss Lang was called in. Her counsel was on the phone by conference call. And it was on the record that she was put under oath. She asserted her privilege at that point, and all of that should be in the record that was presented to the court.
Right, but did they say, I mean, that was the motion, for, I guess, to advance the Fifth Amendment privilege against self-incrimination. But did they say at that point is if we do get you on the stand at this trial, then you're going to face a second perjury charge?
If I recall correctly, the attorney for Miss Lang indicated that it was his belief that her testimony would be consistent with her preliminary hearing testimony. And it was the state's position that there was going to be a second charge if that was.
That was verbalized at the.
I don't have that directly in front of me. If I recall at some point, because I recall the court had, the judge had even mentioned that that the state had made it clear that they intended to charge her again. if that was consistent. And she was in a situation where if she came in and testified consistently, then she was subject to a second perjury charge because they had already charged her and claimed that what she had testified to previously was perjury.
But why does that matter legally speaking? Why, even if that was verbalized to the witness, how is that any different from a prosecutor just saying, if you lie, I'm going to charge you with perjury?
Well, I think it's a little bit different in this situation because they had already charged her
Yeah,
at that point.
it has more credibility. It's not a
Absolutely.
bluff,
Yes.
but legally speaking, why should that matter?
I-
A prosecutor's always entitled to inform a witness that if they don't tell the truth, they may be subject to a perjury charge, correct?
Correct, and I would agree with that. I think what is different in this situation is that it wasn't just a potential threat at that point. It was, she had already testified, they had already charged her, and that charge was actually pending. So that was a reality. It wasn't a, oh, if I
Right, so my
did this-
question is, why does that legally matter?
I
I
think it-
understand that it psychologically matters. It puts more pressure on the
Sure.
witness. But legally is, with respect to the Fifth Amendment, why should that matter?
Well, I think that it matters because she's being put in a situation where she either testifies consistently with what she testified previously and faces another felony charge, which is highly likely to happen since it already happened before.
What's wrong with that if her testimony is untrue?
Because at that point, there had been no determination by an independent fact finder whether her prior testimony was true or not.
Sure.
So the county attorney was being allowed to essentially insert himself as the judge at that point
No,
and say it was false.
again, I'm having a hard time seeing the distinction between that witness and the witness who has not yet been charged with perjury. In other words, they're all subject to the criminal justice system. And if a charge is supported by probable cause, that individual is going to get bound over for trial, just like the witness in this case would be.
I think this is different from just an average witness. And it comes down to that distinction that they had already charged her for that prior testimony, and then they subpoenaed her to come to court and testify again about this, essentially the same set of facts. And so she is put in a position that either she testifies consistently and gets another perjury charge, or if she changes that testimony, then they'd already charged her, I believe it was either another count or in the alternative, the interference with law enforcement from the night of the actual interview. So
Wouldn't she have had use immunity derivative from her subpoenaed testimony with respect to any previously either charged or uncharged crime?
I don't believe that she would have at that point.
Why not?
Well, I mean, none of that was,
Isn't that the scope of the immunity that was granted? Was we won't use your prospective testimony at the trial as evidence for any criminal charge that may either exist or not yet exist in the past.
well, I think one of the issue or the problem here for her is that if she does change her story, then she's admitting to perjury. If she changes it the day of the trial.
How when she has immunity? I mean, that evidence would never get into the trial.
But it would get into the trial through her actual testimony.
No, it would not get into her perjury trial.
Oh, into her perjury trial. Yes.
There's no danger there.
I would agree with that. However, it comes down to then that day, who determines whether that's the truth or not? If she changes the testimony the day of trial.
Let me try to expand a little bit on what Justice Stiegel is pursuing. You're asking us to find in general, not just, any specific facts of this case, but in general to find that the Fifth Amendment precludes that the Fifth Amendment protects testimony on a future charge of perjury. Okay? And that means that what we decide in this case will apply regardless of whether someone has ever been charged with perjury before. Okay, so I know that you're arguing the facts of this case, but your argument necessarily means that for every witness, they will be able to take the fifth, invoke their Fifth Amendment privilege, and protect themselves against perjury.
And I would disagree with that it affects every potential witness. Because this is a very specific situation in which the county attorney had already charged this individual.
But it doesn't make any difference because as Justice Stiegel said, she's already immunized for anything she says at Mr. Adams' trial. Okay, they can't use any of that.
In the current
in
charge.
Her first perjury.
Right.
Okay. All right. So that's a non-issue. I mean, she was granted that and, and they can't do that, but she didn't take advantage of that. But so that's kind of a non-issue. The real issue here is there's only one issue here. And that issue is whether I can, as a witness, invoke the Fifth Amendment privilege against self-incrimination because I'm fearful. So I get to not testify because I'm fearful that I'm going to be charged with perjury. And the United States Supreme Court and every other state and federal court that have addressed the issue basically says the Fifth Amendment does not confer a privilege to lie.
And I don't
so-
disagree with that.
Right. So it does apply to every other case. This case is not different because she was immunized. That first issue is, she was immunized. So it wouldn't have made any difference if she testified because they couldn't use that testimony to prove that she committed perjury at the preliminary hearing. Right? So it's as if she never testified in Adams' trial as far as the first perjury.
Right,
charge.
as far as the first perjury. But the problem is the second perjury that the state had made very clear that even going back to preliminary hearing, that if she lied, he would charge her with perjury. And so it's not just a fear of being charged. It's pretty much a given that that's going to happen if she comes in there and testifies consistently with what she testified to previously. And that's where we're saying that the Fifth Amendment comes in and protects her from that.
Why?
Only if the state can prove she lied, right?
It's the state's determination that they came to that she did lie. And that's what started the entire
Right, but
road that we're
But a
down.
jury would have to find beyond a reasonable doubt that she lied.
Correct. And that is what the district court made clear to the state at the time was the state had said, well, I'll just dismiss it with prejudice. And that should be all in the record. And the court's like, that doesn't solve the problem. You've
We're talking
already.
about the past.
Right.
The issue is not the pending charge because she was given immunity. So I'm not really seeing that, to be honest. I'm not seeing that as an issue at all. Okay. The only issue in this case is, can you not testify because you're fearful when you do that you're going to get charged with perjury? And I think the law is clear across the country that, as Justice Stiegel said, if if you're a prosecutor, you can say that. It happens every day on the stand. You understand that if you lie, you're under oath and you could be charged with perjury. So do you think it's wrong to say that to a witness?
I think it is coercive to a degree to say that to a witness, especially after you have already charged them with perjury the first time around. I think that is coercive. And I think that is where the Court of Appeals was in a degree, was going with this in their opinion, was that it is coercive.
And that strikes me as the heart of your argument and the Court of Appeals decision.
Yes.
And I guess the difficulty that I think I have with that, and maybe others, is that of course it's coercive. Of course it is. That's why perjury laws exist, to coerce witnesses to tell the truth, to provide a strong incentive to be truthful. So can you address that? Like, I don't think you win just by demonstrating that it's coercive.
No, I think that where this, and we had argued this in our brief, was that the court was, or the state was essentially telling her that it believed that what she testified to previously was perjury. And so she was then in a situation of either stay consistent with that prior testimony and face the reality of a potential second felony charge, or change that testimony, whether she changed it to something false or what she testified to the second time, whatever it was. If she changed it, then if it deviated from the truth the first time around, then again, she's committed perjury. So it's coercing her into either staying consistent and getting charged again, or changing her story because the state didn't like the first time what she presented it in her testimony, and committing perjury again. So it's essentially state sanctioned perjury if she changes that. That's the situation that she's put into there. And I know that the state argued that they weren't telling her what to say or anything. They didn't have to tell her what to say on the stand. Just coercing her to change her prior testimony is essentially telling her to say something different.
Well, doesn't that, as opposing counsel say, let me go back, necessarily force us to infer that a prosecutor is improperly using a threat of a second perjury charge to get a witness to change their testimony? I mean, we necessarily have to assume malintent.
I don't think that it's necessarily that you have to infer that it's malintent, whether it was that, or whether it was just his verbalization with no intention to cause harm or something of that nature, without it's just something he said. The fact of the matter is, it holds real weight when a prosecutor says that to somebody.
But isn't it, as Justice Stegall just said, yes, it provides a strong incentive to tell the witness to be truthful. I mean, I don't see how that's coercion. Just tell the truth. And I would also ask you that if she wouldn't have told a different story at the scene of the crime, none of this would be, this was basically the factual record demonstrates that she told a completely different story at the scene of the crime. And had she not done that, then we wouldn't even be here today, right?
Well, and I think, and it was included in the facts that were included in the briefs, I think that a big part of this was that she talked about how intoxicated she was the night of the incident, that she didn't remember exactly what she had said. And so,
Well, we're not really talking about that though, are we? We're not talking about memory fading, forgetting. Sometimes memory even morphs where you think you remember something that couldn't have happened. We're not talking about any of that. That's not perjury. Is it?
no, I think that one of the issues with Miss Lang was that and I believe it's somewhere in the record, that she said, I don't remember saying that. I didn't know what I said to law enforcement. I wanted to see my written statement because I didn't remember what I wrote. that was all brought up during the,
But she remembered vividly taking the pulse of the victim. It didn't the court take that into account?
I believe that she mentioned that she remembered taking the pulse of the individual. Correct.
Can I ask one question? The right we're talking about is a personal constitutional right under the Fifth Amendment, and that right belongs to Miss Lang. She's not here. She doesn't have counsel. Is that an issue? Is that a problem? If so, what do we do about that?
I fully anticipated that, that there would be an additional brief that was submitted, but that did not happen, so I'm here. There are no other questions. Don't have any other presentation. Thank you.
Very briefly, I do want to clarify something from that Justice Standish asked. I don't want to mislead the court. When it comes to whether or not the prosecutor actually on the record threatened a second perjury prosecution, I don't think that's in the record, but I'm not sure. I'm not asserting that that is not in the record. I don't believe it is, but I've been wrong before. So
The Court of Appeals opinion on page 3 says that at the start of trial, there was a discussion, and while explaining, quote, the state's theory as to why Lang could not assert her privilege against self-incrimination, the prosecutor told the district court he viewed Lang's preliminary hearing testimony as perjury, and therefore any consistent statements would be perjury again.
that it could be in the record. I'm shooting from memory here, so I just want to make sure I'm not trying to mislead the court. I mean, it could be that I don't recall him like face to face with her saying, if you if you testify the same way as he did the prelim, I'm going to charge you with perjury. I don't think that kind of direct thing happened, but obviously if it wasn't articulated, it was certainly implied. I mean, that was kind of the crux of why she was claiming or trying to claim the Fifth Amendment. But ultimately, as the court has already recognized, that doesn't matter, because the threat of charging someone with perjury if they testify falsely or inconsistently with prior statements does not create a Fifth Amendment right.
But what if it was the truth? What if the preliminary hearing testimony was true? Just hypothetically. And a prosecutor, I'm not saying this prosecutor, but hypothetically a prosecutor said, if you repeat what you said at prelim, I'm going to charge you with perjury. Directly said that. I mean, that seems like imminent peril, and the Fifth Amendment seems to protect protect a person from compelled truthful testimony that would be incriminating.
Well, and that's why we have a court process, and the courts would protect that witness from ultimately being convicted of perjury. Probably wouldn't get past a preliminary hearing, and the prosecutor would probably soon find himself in front of the disciplinary.
But the Fifth Amendment in that situation would mean that witness would never have to say anything on the stand, so they could avoid that peril, right?
I'm not following. I mean, the thing is, if it's truthful, it's not incriminating. It's not incriminating the witness for any past misconduct. It's not.
What if it was truthful and incriminating, I guess?
Well, if it's incriminating, well, then we do have a Fifth Amendment. At bottom, and this is the problem I have with the Court of Appeals opinion, the Fifth Amendment provides a right to refuse to testify about something that will incriminate you for some past conduct. It does not give you a right to refuse to testify because you just don't want to tell the truth. And that's what we had here. She didn't want to tell the truth.
What you're saying is that the Fifth Amendment does not protect a person against being falsely charged with perjury.
I think
Is
that's
accurate.
That's accurate. I mean, there's no way to prevent somebody from being falsely charged with anything other than.
I mean,
the
because
court
that
process.
is the defendant, that is the crux of the defendant's claim. The crux of the Court of Appeals is that the fear of being falsely accused of perjury is enough to justify asserting Fifth Amendment.
And as the state made the argument, and as the dissent made below, that's every witness faces that. I mean, every witness that takes the stand could, in theory, be falsely charged with perjury. Every witness faces that. It's not unique to this witness. There's no Fifth Amendment right to refuse to testify because you think you might commit perjury or might be charged with perjury. I mean, the case law is clear on that. And so again, I would ask you to reverse the Court of Appeals and agree with the dissent below. Thank you very much.
Thank you to both counsel for your arguments in this matter. We'll take this case under advisement. Court is now in recess until 9 a.m. tomorrow morning.